Senator Grassley, thank you very much for chairing this hearing. It was a little over 2 years ago when Senator Lee and I introduced the first version of this bill, trying to call for sentencing reform, particularly when it came to mandatory minimums. I thought we made a good faith effort. We drew a lot of co-sponsors, but we wouldn't be sitting here today with the very real prospect of enacting this bill into the law of the land had a number of people not joined us in the effort. First and foremost among them is chairman of this committee, and that's Senator Grassley, who didn't care much for our first version of the bill and said so. And we sat down with him, and also with Senator Cornyn, Senator Whitehouse. Senator Lee and I joined with Senator Booker, who was also part of this effort, to try to craft the effort before us today. It was a lot of hard work involved in it, most of it done by our staff, and that's the case around the United States Senate in most instances. But I think at the end we have a product well worth the title of meaningful, historic reform. And I want to thank Ms. Yates from the Department of Justice for encouraging us and grading us as we made progress on this effort. I'd like to address a couple things that we wanted to make clear. First, we believe that there are many nonviolent drug offenders currently serving lengthy mandatory minimum sentences, and that is the category that we were looking at. In 2011, the Sentencing Commission did a comprehensive study on mandatory minimums. They found 55,000 people were in federal prison serving mandatory minimum sentences for a drug crime, 55,000. That's more than 50% of all federal drug offenders and more than 1/4 of all federal prisoners. Many of those serving are low-level offenders, and it's true that some low-level offenders like couriers don't often receive mandatory minimums, but other low-level offenders frequently are sentenced. So what is your response to the claim that this is much ado about nothing, that we're really not going to address or potentially address a large sector of the federal prison population?
I think that we absolutely will. If you look statistically at the profile of drug defendants that are currently in the Bureau of Prisons right now, you'll see that there are a number of what we call low-level nonviolent drug defendants. For example, less than 1% of the defendants in federal prison actually had violence or threats of violence in connection with their drug offense. Only 16% of them had a weapon. Half of them had little or no criminal history at all, and only 7% of them are leaders. So just those statistics alone should tell you that there's a fairly sizable group of folks out there that don't need to be serving a prison sentence for as long as they are, and that's what I believe this reform is designed to address.
So my colleague, Senator Sessions, rightly addresses the incidence of murder and violent crimes, and what we have tried to do in crafting this safety valve provision is to make certain that if you are engaged in those violent crimes, using firearms and such, you will be ineligible for the safety valve aspects of this bill. So I applaud him, and I think he's right. I can point to the city I represent of Chicago and other cities where violent gun crime is up dramatically. I don't want to make it any easier for those who are sentenced under those circumstances. But do you see the distinction here between violent crime, murder, and what we're trying to achieve with these drug offenders?
Absolutely, and again, that's why the individualized assessment in each case is going to be so important. We'll look not only at what the offense of conviction was, but also the defendant's history. And we will be addressing the concerns that you've had there to be sure that we are only cutting sentences, again, for those low-level, nonviolent drug offenders.
And to repeat what's been said, the bill does not repeal any mandatory minimum sentences, does not repeal any of them. It establishes two new ones. It raises some maximum sentence, and it does not lower any maximum sentences. So when you're dealing with the bad actor, that judge still has an opportunity to sentence at the highest level, the maximum level in this case.
Absolutely. That's one of the things, a mandatory minimum is just that. It's the floor for a sentence, not the ceiling.
There's another aspect that Judge Wilkins, who was appointment of President Reagan, first chair of the Sentencing Commission, here's what he said: there are few federal judges engaged in criminal sentencing who have not had the disheartening experience of seeing major players in crime before them immunize themselves from the mandatory minimum sentences by blowing the whistle on their minions, while the low-level offenders find themselves sentenced to mandatory minimum prison terms so skillfully avoided by the kingpins. What we have tried to do in this is to make it clear: kingpins are not going to get a break at all in any of the changes that we make. Is that distinction clear to you as a former prosecutor?
It is clear, nor should kingpins get a break.
Thank you.